criminal law on abortion is a wrong in and of itself, not only because of the public health consequences, because of how it destroys women and the meaning of women in society.
Particular vulnerability, stigmatization, criminalization, other burdens like a requirement to travel. If any of that sounds familiar, then I thought I might spend a moment thinking about how that might actually be applied.
I also really wanted to show the court sort of the full range of situations reflecting the reality of women's experience trying to obtain abortions. These were not desperate women, but they were real women and families, and they were going through what is a daily experience in Ireland of trying to access necessary services.
Specifically, the Commission identifies the specific position of girls and women from minority ethnic backgrounds, from non-English speaking backgrounds, the position of women and girls in the context of a fetal anomaly or in the context of rape. And they specifically call on the state to consider reassessing the current constitutional position, given that it prohibits access to a lawful abortion for women and girls in such situations.
The tension between what I see as abortion rights as a real central to gender equality and to women's ability to participate in society, to control their lives, their dignity, their health, and other things, and that the court, most courts that have looked at this issue, except I believe Canada's, have said it's about privacy rights.
If we look at the jurisprudence and the concluding observations of the UN human rights treaty bodies, increasingly we are seeing recognition that this is an issue of equality and one of gender equality.
My argument in this paper is that we, as a movement, have to move from thinking about the statistical woman. We all have statistics on how many women travel to England for abortions, but we have to move from those statistics, as helpful as they are, to think beyond the statistical woman, to think about the criminally constructed woman.
Criminalizing abortion is unfair because it asks women, rather than the state, to bear all the weight of the public duty to vindicate fetal life. It's a form of privatizing public responsibility.
State responsibility under international law lies with the state, and it's hard to imagine another context where the state simply discharges or displaces its obligations by saying, well, a person can go elsewhere to another jurisdiction, to another state, and have their rights defended or vindicated there.
Stigma is inherently wrong. It degrades, it's cruel, and it's a form of social control. But perhaps most perniciously, it is arbitrary, in that it is a decentralized and unlinked to any explicit form of institutional authorization or accountability. No one need take responsibility for imposing stigma.
I've seen more and more of a coalition feeling emboldened to speak out on the abortion issue, and to me that's very gratifying, because I think the silencing of even the political conversation around abortion really impacts the women who are going through making that decision and helps to perpetuate the stigma.
The stigma analysis helps us to add meaning to how we treat women in society. It also enables us to go beyond the focus on individual suffering to show how the criminal law on abortion is systemic. It has systemic consequences. It causes women in society to be discriminated against as a group of women.
Part of the reason why grounds for abortion have been drawn so narrowly in Ireland is because the life of the unborn has been treated as if it is the same as the life of the pregnant woman. But recognizing a right to life of the unborn does not have to mean that the unborn's right is the same as the woman's right in law. Equality does not mean sameness. Women are conscious, sentient beings with moral views and responsibilities, with affective and material relationships, when fetuses are not. That's the de facto situation. So equality between the two has to address that.
Criminal law scars. As the U.S. Supreme Court said, It affects the hearts and minds in ways unlikely to ever be undone.
There's nothing in Article 43.3 itself which requires the legislature to criminalise abortion, right? You can defend and vindicate unborn life without criminalising women's reproductive decisions.
Last week, we had the list of issues from the Committee Against Torture, and we see a reprise of these concerns. Whether adequate guidelines exist for medical and other professionals to carry out legal terminations, whether there are adequate services to carry out abortions, whether current legislation regarding termination of pregnancy upholds a woman's right to freedom from discrimination and to prevent other breaches of the Convention.
Also, we have an upcoming review before the UN Human Rights Committee under the International Covenant on Civil and Political Rights. And there again, we see a range of issues being raised by the committee, being put to the state as to whether or not it is complying with its obligations under that treaty, including in particular its obligations of non-discrimination.
It's my view that the door is sort of wide open at the European Court of Human Rights for more work to advance access to abortion and reproductive health care. But I think that we need to be particularly careful that we don't have advances that leave marginalized women behind, that we need to sort of move everybody forward. And we don't want to perpetuate this false and unworkable distinction that I see between abortion that's necessary to preserve a woman's life and that is merely necessary to promote her health. I think it's very important to recognize that kind of continuum of health and life.
We have seen further movement in terms of the jurisprudence of the European Court of Human Rights in the ORR and PNS cases against Poland, where I think we have seen greater attention being paid to the levels of mental anguish and suffering caused to women and girls who are not given effective access to lawful abortions. And I think it's quite important that the Commission published these observations and specifically identifies areas where further reform, including review of constitutional provisions, is required if the state is to be compliant with its human rights treaty obligations.
The state should not wait, and if it does, then those of us who have a commitment to progress in this area through the use of law certainly should not.
I don't see the courts as sort of taking a giant leap out and bringing society along with them, and I don't think they see that as their role, so that it becomes about creating social change and making the court feel comfortable enough. And I think that's where the movement and the block building really has to happen.
Because of the individual and systemic harms of criminal law on abortion, any criminal law on abortion, including the Irish criminal law, we cannot justify the use of criminal law to protect prenatal life.